Hi guys, it's Kathy. I hope you're doing well. So I got a clip later after this one for Charlotte. There's a French interpreter, and the defendant sounds amazing, but he only speaks just a tiny little bit, and it's a shame because this voice, he speaks only in French, and it is so good. But this first clip is from a couple years ago. Okay, this did not just happen. This guy's pro se, okay? And he was arrested. So they stopped him. They searched his vehicle. They did a strip search. They detained him at the police station. He had to go to the emergency room. I don't know if it was to take blood or okay. When they stopped him and searched him, they used force. So he was complaining about injuries from that. So I know that he was treated for those there at the hospital. I don't know if they did a blood test as well or not. So he was found, the drug case that when they arrested him for drugs. That was dismissed. That case was dismissed. So now he sued every nurse and doctor at the hospital that was involved in his care. He sued every prosecutor involved in this case. He has sued the police station and all of the officers that were involved in his search. The normal Fourth and Eighth Amendments were violated. He has sued the mayor. He has sued the chief of police. And then he has sued the state of Iowa. He sued every single person that had anything to do with his case. And he's pro se. So he does not have a lawyer. So what we're doing now is this is a motions hearing. All right. So we're going to watch. He has a motion for summary judgment. And we're just going to find out whether these cases go any further or not. Actually, he has some good points. Now, remember, this was years ago. This wasn't today. Today, he might have done a lot better. But since it was years ago, this is what happens. Let's see. And you have to be able to hear it. So before I even did anything, I felt the left with the right. I boosted the volume. So there's just not a way that you're going to say to me, I can't hear anything. Unless I mute it by accident.
I'm Judge Wolle, and we'll make sure that the video setup is working before we get started, Ryan. All right. And Linda Egbers is our court reporter. And this is the hearing on the motion for summary judgment of a number of the defendants. In this case, we've already had one hearing as to several defendants. I think Genesis Medical and some Scott County defendants. The proceedings today will be to hear from Mr. Hammock and also from counsel for the defendants. Who will be presenting on behalf of defendants?
I will, Your Honor. I'm Chris Jackson.
All right.
And I represent the 12 defendants that are the subject of this motion.
All right. And my proposal is that you have up to 30 minutes to make your argument on behalf of all of those persons. Then I'll give Mr. Hammock the equivalent amount of time to respond. Keep in mind, of course, that I have read all the papers. I ask that you not just repeat what's already been written in your papers, but focus on the fundamental issue here, which, as well stated in Mr. Hammock's briefs, has been whether there are genuine issues of fact disputed that, if decided in favor of Mr. Hammock by a jury, would allow him to be successful. But those facts have to be sufficient legally to support a decision in his favor. And in reviewing all of the facts that are presented in the papers, I give the benefit of the doubt to Mr. Hammock, which is to say that I look at all of the actual evidence in the light most favorable to him. But at the same time, he has a burden to show that there really are genuine disputes. Mr. Jackson, I'll hear your argument.
Thank you, Your Honor. There's a variety of grounds for upon which the 12 defendants rely for their dismissal. And I'll try not to be repetitive of what I've written, but just kind of touch the highlights. The city of Davenport, the police department, Mayor Gluba, and Police Chief Frank Donchez are all entitled to dismissal because they're only identified, and the only theory that's presented in the petition is respondeat superior. And as the Supreme Court has already ruled in Monell versus Department of Social Services of the City of New York, that respondeat superior in and of itself is not sufficient to keep governmental entities in a lawsuit. There's got to be.
Let me interrupt for just a moment and ask, because Mr. Hammock, this seems to be the simplest of the issues that's raised by the defendants. How can you be successful against the city, the police department, the mayor, the police chief, when they were not directly involved in any way in any of the actions about which you complain?
Yes, Your Honor. The Monell versus Social, in that case, the Supreme Court, it was stated that, from my understanding, that when it shows a pattern of behavior, and I listed the chief and the city and the mayor because they were the ones ultimately responsible for the pattern of behavior and the not training the officers adequately. And the many facts that I cited, which are my disputed issues of material fact, is that it's a pattern that's indicative in the case that I presented, the complaint that I filed, to show it was a normalcy of behavior. So
what proof is there that that was similar to what was done in any other situation earlier?
And you're referencing my complaint?
Yes.
What do you mean?
It's easy to say this is a pattern of earlier events, but I don't know of any earlier events.
Well, I was specifically speaking about the events of what happened to me and the continuation, the withholding of exposure.
Oh, he loses, guys. Right there. He lost his whole case. When he specifically said that, he specifically trashed his whole specifically case.
Compensatory evidence, which was the cell phone information, the withholding of the video, which shows that I'm repeatedly in a pat-down search thrown to the ground, the withholding or the destruction. I don't know if it's withheld, destroyed, or it wasn't recorded, where I was forced to urinate on myself. There's no record of that.
Well, withholding. You're not understanding my question. Listen carefully. When you're talking about a pattern and practice, it has to be something that is similar to what's gone on in the past.
In another case is what you're...
In many other cases, usually.
That's the question you're asking me.
And is there any evidence here of what happened to other people in other circumstances?
In this district, or you're just saying in any case?
As to these four defendants: City of Davenport, Davenport Police Department, Bill Gluba, Frank Sanchez.
And that's the thing. That's the whole thing with the withholding of information. There's no way to know. The case itself, my complaint, shows a pattern, but them not being forthcoming with information and within the case, and that's why I point to my case, it shows a normalcy of behavior. So I'm sure.
Okay. So How do we like this pro se guy so far? We got to hear him speak for a little bit. He's not as bad as the other ones, I think. I mean, he's doing okay, I think, so far. I think if I had a choice between this guy and this guy representing me for something, boom, I'm going with this guy right now. I think he is beating him.
There were other cases looked at involving these officers, and particularly this particular local administration. It was so indicative that it speaks to a pattern of behavior.
I'm sure you are sure it must have happened,
Yes.
but that's not good enough for my being able to look at evidence of what happened before.
How am I able to know that without actually experiencing that situation myself?
Sir,
I can't jump inside a person's body and know.
I don't have any way of giving you advice on how you are able to learn about and rely on circumstances in your case. I can only tell you that so far, I don't know of any basis on which those four entities can be held liable, because just because they're in charge of other people doesn't mean they can be held in this federal civil action. You can come back to it, but now we'll continue with Mr. Jackson.
Guys, Discord is great. I know some of you are not okay with it, but it's great. We all can talk to each other 24/7 about everything, anything. I mean, you go there, you see the weirdest things. We saw France yesterday. We saw France in the last 48 hours. And it was amazing. And every time you go there, you see something else amazing. So come on to Discord. If you're not in Discord yet, just try it. You don't have to say anything. But the more you talk, the more everybody else talks. And everybody's ready to talk.
Your Honor, there's another defendant, Austin Keene, who's identified at the outset of the petition and then never referenced anywhere in the 109 paragraphs, and he should be dismissed for a failure to state a claim. He's simply identified as a police detective. Moving on to Officer Mayhew, nothing that he was alleged to have done in the petition rises to the level of a violation of civil rights. He simply escorted the plaintiff to the hospital and into the jail from the hospital.
Thank you, security. Thank you.
Then we're presented with Officer Sam Miller, Brad Jensen, and Epimenio Canis, which I kind of discussed all together. They're immune through collateral estoppel or issue preclusion, because in the underlying criminal case where the plaintiff was a defendant, what they were alleged to have done, namely to stop him, to search his car and his person, and to arrest him, the constitutionality of that has already been ruled on by Judge Talene of the State District Court. And in the case of Depew versus Swearingen, which is an 8th Circuit Court, he's collaterally estopped from litigating those claims over again civilly. In Depew, I just point out that the underlying facts of that case are virtually identical to the present case. It involves a defendant who alleges that his Fourth Amendment rights to search and seizure were violated. The judge in the criminal case ruled that they were not, and he proceeded with a civil lawsuit. And then those defendants were also entitled to qualified immunity. And I'm sure the court's well aware of the two-part test for qualified immunity. In the first place, was there a deprivation? And in the second place, were the parameters so well established that a peace officer would know that he was committing a civil rights violation? In the case of those three individuals, I don't believe that there was a deprivation of their civil rights. They simply made an arrest for which they had probable cause, and they made a canine search of the car for which they had probable cause. Moving on to defendant James Quick, the only allegation against him is that he did the pat-down search, the first pat-down search of the defendant, and he's entitled to qualified immunity also. I think he passes the first prong of that test, that there was no deprivation of the plaintiff's rights in any way. The plaintiff was already in custody at that point in time, and Officer Quick simply did a pat-down, and he felt a suspicious object, in the seat of the plaintiff's pants, and he called for another officer to verify his suspicions. He then was the one who went to a supervisor for permission for a strip search. And again, we have Pat Sievert and Jason Smith are the only two defendants left of the 12, and they're both entitled to qualified immunity. I think that they passed on the first prong of the test. I don't think anything they did resulted in a deprivation of any of the plaintiff's civil rights. Jason Smith was the supervisor, and he gave permission, written permission, for the search to take place, and he lists the factors that caused him to authorize the search: the bulge in his pants, refusal to answer, nervousness, the circumstances surrounding his arrest, that his colleagues were taken into custody with large amounts of cash and illicit drugs, and the request to use the bathroom. And the court in Bell v. Wolfish, the U.S. Supreme Court, lists 4 factors in deciding on the justification for a strip search. The 4 things the court looks at are the scope of the search, the manner in which it's done, the justification for it, and the place which it was done. In this case, the scope was no more than to discern that the suspicious object was the bicycle shorts that the plaintiff was wearing, the padding in his seat. The manner in which it was done was as professional as could be expected under the circumstances, given that the plaintiff was not cooperating. The justification, we've just gone over that. And the place was in a private place away from any video cameras. And his response, the plaintiff has alleged that he thinks there's some video that's going to show the strip search, and there simply isn't any. And I'd call the court's attention to our appendix, where I've included the Davenport Police Department's search policy. Page 12 addresses strip searches.
I just tried to delete Fozzie's comment and I banned him from the channel completely by accident. Fozzie, say something. Oh, he's back. All of his comments are gone, but he's back. I don't know if he has a crown anymore. I tried to delete.
In sub 4, in parentheses, it says searches will not be conducted in interview rooms equipped with video recording systems. That's to protect privacy rights of the person being searched. And if the plaintiff thought that the police department was unfairly withholding evidence like videotapes, his defense attorney in his criminal case, who's a very experienced defense attorney, Harlan Geese, would certainly have had the opportunity to have done a motion to compel in that case to get that evidence. The plaintiff's also alleged in his response that he hasn't had full and fair opportunity to litigate the ruling that Judge Talene made on the constitutionality of these stop and the search and seizure, and yet he was represented by experienced counsel. Again, Harlan Geese. And Mr. Geese, on behalf of the plaintiff, who was defendant in that case, could easily have asked the judge to reconsider or could have filed an appeal. So I believe he did have full and fair opportunity to litigate that. And if the court feels that there was a deprivation by way of the strip search, I think there's a matter of law. The second prong of qualified immunity entitles the officers to qualified immunity in this case. And I've cited a couple of Supreme Court cases, Safford Unified School District versus Reading, where qualified immunity was given in a strip search of school children where a principal was looking for pills. And they quote from the 11th Circuit, Thomas v. Roberts, in which a police officer was given qualified immunity for a group strip search of a 5th grade class for a missing $26. So I think regardless of the viability of the search, I think that the parameters, if a constitutional deprivation is considered by the court, the parameters are not such that the officer should be denied qualified immunity for conducting the strip search. The last claim is one at the end of the petition, and that's cruel and unusual punishment. And I'm sure the court's well aware that that's not appropriate because there was no formal adjudication of the plaintiff, which would trigger such a constitutional protection.
I didn't catch that. There was no what that would support?
Oh, no, it was absolutely drugs. And they sent it to get tested, and they tested positive for drugs. Marijuana, But no, he absolutely, wait, I did fix it. What do I have to fix? Hold on, guys. Fozzie needs fix, so I'm going to fix it. Fix what? I don't know what to fix. Are you not a mod? Hold on. Hold on. Oh my God, Fozzie's not a mod. I have to go check out everything else. Okay. Green. Yeah. Fixed. It's fixed. I'll go get the other stuff in a second.
Cruel and inhuman punishment.
There was no formal adjudication of
No
guilt.
formal adjudication. I didn't get that. Thank you.
No.
I'll give you a chance to reply briefly at the end of Mr. Hammock's response, but Calvin Hammock, this is your opportunity to support the claims you have made against each of these defendants, and you may go back to the ones that we've already addressed when I asked you about the city of Davenport, the mayor, the police department, and the police chief, but now you should probably focus on those persons who you contend actually did something rather than contending they should be held liable for what others did. So take a deep breath and give me your best shot.
All right, thank you, Your Honor. Your Honor, I was arrested on August 6, 2010. Allegedly, the original complaint of the affidavit and complaint, which is Exhibit V in my complaint, was by Brad Jensen, and it says that I was arrested for crack. No mention of marijuana was mentioned on August 6, 2010, but it was referenced later after a search warrant was conducted of my 3 cell phones. Now, I have to fast forward for a minute, because in Judge Talene's ruling, which the defendants have stated, it would be Exhibit W, page 5 of 18. The judge stated that the officers searched the defendant's person at the police station, and the officers found and seized $100 and 3 cell phones. That's not accurate. And my exhibit page 67 of, it would be attachment B of the motion to suppress, proves it, because the officer Jensen says on line 3, line 1, the question was asked, to be clear, was a search conducted of the vehicle? Yes, ma'am. Cell phones were taken from that vehicle. So in the judge's ruling, he was inaccurate as to what was testified to. It could be minor, but it actually is significant when thinking about and examining the shakedown itself, the multiple shakedowns that was done to me before the actual strip search. And also, the judge mentioned, and a search warrant was subsequently obtained to search the contents of the cell phone. No testimony was ever given to the contents of the cell phone. So in that, I never was able to have a full and fair opportunity with that. Now I'm gonna go back. I'll get back to that. I'll go back. I was arrested. So no mention of the marijuana was done. August 16th, a search warrant was done for the cell phones. I believe, and it's my contention, and I believe I have enough genuine issues of fact that coincide with what I'm saying. The only time marijuana was mentioned is when it was shown.
Remember, you said that. Remember, those are the words that you used, okay?
That I had no connection with this person that said I gave him some crack. There was no connection at all. And I believe the defendants, in order to justify their arrest of me and all that stuff that happened to me in the police station, they had to go back and say, well, listen, the original affidavit says crack, no mention of marijuana. We got to make the arrest look legit. So let's say marijuana. Marijuana wasn't mentioned until after the contents of the cell phone was searched. No mention of the cell phone. My attorney, Mr. Harlan Keese, whom the defendant's counsel had just spoke about, he even submitted an affidavit and stated what we didn't get after Judge Mark Smith ruled. As far as in the Brady, it was a Brady motion, and the ruling the motion was granted in its entirety. And I'm just now, in the last couple of weeks, got the strip search authorization form saying, and we were supposed to been had that. As far as filing a motion to compel, is there a need to file one once the judge gives an order? And this is indicative of a practice and pattern. Now I'm going back to the marijuana. So the marijuana.
Just a minute. Let me make sure you understand why I'm troubled when you say this is proof of a pattern. What happens today,
yes,
is not a pattern of what happens today.
okay,
There has to be evidence of what has happened in previous instances of a similar nature that would show that the defendants have a pattern or practice of doing improper, unconstitutional things.
right,
It's easy to throw out and say, see, this proves a pattern.
right,
But what's happened to you didn't prove any pattern. It only is the last event of what you would have to prove as a series of events that would establish pattern. Do you understand why I'm coming back to that?
yes. Now, and this I think is important, a matter for the jury to determine, because I would like to ask those officers under oath in those instances, have you ever done this before? And then those answers to those questions, we can delve into that and find out about that. But I'm specifically speaking about what happened to me, and I believe Canton versus Harris, which I quoted.
Give me that a citation again.
Yes, sir. Canton versus Harris in regards to municipal liability.
All right, I understand that. Go ahead.
Do you want me to cite it, or?
Well, spell the words for the court reporter.
Canton versus Harris.
Specifically. Donald, thank you so much. I appreciate it. Thank you.
Harris.
Thank you. Now you may continue.
Okay. Now, in relation to the marijuana, I have a report I would like to, am I able to submit documents to the court and the defense right now?
Any objection to that, Mr. Jackson?
I'd like to see him first. I don't know what he's going to object to.
Start with one, and then we'll go with others if there is a basis for it. Usually the evidence has to be presented before the day of the hearing on summary judgment.
Yes, sir. This is a marijuana testing officer report signed by the Assistant County Attorney Calvin and by Officer Delane, who was the testing officer of marijuana.
And the date?
The alleged police report.
And the date?
The date on this is, it was filed October 22nd, 1925, made by the county attorney. And the other page two of this exhibit is the date that I see on here, the latest date, October 16th, 2002.
And this is from the court proceedings in Scott County.
Yes.
Any objection, Mr. Jackson?
I don't see the relevance to the civil case here, Your Honor. And it just says that there was some marijuana that was received and was tested. Didn't say where it was found or the circumstances around it. So I don't think there's enough foundation for it. And I reject on relevancy grounds as well.
Well, I'm not going to take many more documents. I'll receive this one subject to those objections that are made, and we'll have it. Is it marked as an exhibit at this point? Pardon?
Exhibit 5.
Okay, Brian, if you'll take exhibit 5. And then was there another document?
Exhibit, yes, I have another document in relation that my attorney sent to the Davenport Police Department asking for a video of the from the time of August 6, 7 p.m. to 11 p.m. And the response by the video officers that the Davenport Police department only retains video for no longer than 120 days.
And this is Exhibit 6?
This is Exhibit 4.
Oh, I have 6 here. What's that?
I'm sorry. They're supposed to say Exhibit 5. Does it say Exhibit 5 on it? If it says 6.
One says 5 and one page says 6.
The second page says.
Why don't you square that around with what he has?
Okay, I don't know. Look, this looks like the bailiff, right? Is this the bailiff just sitting there while this guy walks right up to the judge? Did that just happen, or I don't know, because I can't see past there.
Okay, 2 pages, Exhibit 5, which appeared to be 6, but it isn't. Okay, continue. And now you have 4.
The Exhibit 4, this is, my attorney sent a request to the Davenport Police Department, which they responded saying they need video for 120 days. This is in reference to the request for the video that was never received, and I'm in my complaint. My argument is that the reason the video.
Iowa. This is in Iowa. How often do you get to see a courtroom in Iowa? Almost never. What do you see when you come on Court Vibes? Iowa. It's from a couple years ago.
Was destroyed and wasn't retained is because I believe, and it appears to be an issue for the jury, why wasn't there a video? Now, my contention is if I would have assaulted an officer or done something wrong, there would have been a video. But because I was the one who something was done to, there's not a video. And there should have been a video. And then the question speaks to what are the procedures regarding video? The fact that I was forced to urinate in the room, being held in the room, and no video of that. When there was a video in the corner, why isn't there a video? And what is the procedures and the policy regarding bloodborne pathogens and bodily fluids? Who cleaned up the urine? Because
is there an objection to Exhibit 4?
Yes, Your Honor, for lack of foundation. The plaintiff has already said that he was arrested on August 6th, and this doesn't come from Harlan Geese. It comes from the Balin McCormick law firm. It's dated June 24th. I have no idea what it's concerning or what it's about, other than it's about video footage.
24 of what year?
2011.
But the request was for video footage on the first page from the Balin McCormick law firm. The request was for video located at the police department and 1416 Harrison Street, Davenport, on August 6, 2010, between 7 p.m. and 11 p.m. And that was the time I was arrested. And that was the time I was forced to urinate. That's the time I was multiply shaken down. My genitals were fondled and I was thrown on the ground. That was the reason for the request for the video.
Where does Balin McCormick law firm fit into this case?
The Balin McCormick law firm is a firm that I deal with on my business. So they're a law firm that I deal with, and they're not a criminal law firm.
So they were not representing you in the criminal case?
Complaint, no, but they submitted a request for a video, and we were determining if they were going to represent me in a civil complaint.
Oh, I see. So that was a potential lawyer to represent you?
Yes.
Which lawyer in that firm?
David Nelmark. This is my trademark attorney. So.
All right. Thank you. The objection, I'll reserve ruling. The Exhibit 4 is received subject to the objection. And now, other documents?
No, but I will be referencing what's already part of the complaint.
That's fine. Continue.
All right. And so here it is. It appears, and I believe this is a matter for the jury, if I was legally arrested for
Wrong body part. Think back further.
For the marijuana, why wasn't it put on the original affidavit and complaint? And my contention is I'm asserting that it was done, the marijuana was brought up later to justify the arrest. Now, let's get to the marijuana. The marijuana, my vehicle was told, Officer Miller wrote on the report, which is Exhibit A, page 5 of 6 and page 6 of 6. In Exhibit A, that's part of the complaint, the vehicles that were involved and the vehicles that were towed. The vehicle that was in, there was a vehicle that was towed, which was the vehicle I was in. It was a Nissan Maxima. It was the only vehicle towed. There was another vehicle involved, which was a Bonneville. This vehicle was not towed. The Bonneville had crack, according to the police. I don't know. I'm just going off the report. The Bonneville had crack in it. The person that ran from the Bonneville had crack. It was stated on the report, the property information, 21.6 grams of crack cocaine was confiscated, 1.8 grams of marijuana. This marijuana and this crack had nothing to do with my vehicle, but my vehicle was towed. But later, it was stated the marijuana that was found in my vehicle stated by Officer Jensen, the dog buddy alerted to the vehicle. He let him in the vehicle. The dog went to one of the seatbelt clips. He alerted again, went to the front floorboard, and the officer states the marijuana flew in the air and landed on the seat. The marijuana, I guess it flew in the air, landed on the seat. The officer Jensen states he collected it in one instance, then he says officers collected it. So there's still a matter of who collected the marijuana first, did Jensen collect it or other officers? My question one is, why does it take officers to collect such a small amount of marijuana that it floats in the air and lands on a seat? When did they collect it? Because in his statement, he say he later collected it. But on his stand, he says something different. So that's an issue, I believe, for the jury. And I would like to hear Mr. Jensen's response. And I never was afforded a trial on the marijuana, so we never got a chance to get to all that. Now, this marijuana, the reason why I submitted the report, the marijuana report, Officer Jensen said he tested the marijuana. Now, this is not the 1.8 grams or the crack. This is not listed for why my vehicle was towed.
This is different marijuana, just so you know. This is different marijuana than the marijuana they found on his person.
None of this is on there. He said he tested positive. Herb Denane on October 16th, again, he tested the marijuana. Supposedly it was so small for whatever. I still, if it flabbergasts me to how this is even a part of the record. In any event, he admits to destroying
you mean
Denane, the officer Denane. My contention is that Jensen fabricated the marijuana. My contention is that all this stuff looks mighty suspicious. Officer Denane, he states on the form, and this is one of the main reasons why I submitted this. It should be noted that the marijuana from item 19 was consumed and tested. He's basically admitting that he destroyed the evidence. So I was arrested for marijuana, which it wasn't stated at first. Later, when the cell phone information showed that, hey, this guy over here making a statement, there's no connection here. Now we got to figure out a way how to make it seem like our arrest is legitimate. All these things were done to mislead the court. And also to purposely destroy evidence that you say I was arrested for. I mean, this speaks to a greater issue and a greater problem.
No, actually,
and
no.
These are things
This is not a criminal trial. This is a civil trial. He is pro se. He sued the state. He sued the mayor. He sued the police department. He sued the individual officers. He sued the hospital, the doctors, and the nurses that all touched him in any way, shape, or form during this arrest. He was pulled over, arrested. They found marijuana in the car. They found marijuana on his person. And then the case was dismissed. The drug case was dismissed. I don't know why it was dismissed, but it was. But because it was dismissed, he's suing them all for arresting him and impounding his car to begin with. He's suing everybody. He sued every prosecutor on this case. So right now, we're in a motions hearing. He's motions for summary judgment, and that's what we're doing today.
I think the jury should hear. The destruction of evidence, you arrest a person for this, and then you destroy the evidence. And my contention is that it was fabricated anyway. It was fabricated because when it was shown that I didn't do, there was no evidence linking me to this person that said I gave him crack. When that was shown, then the defendants had to figure out a way to justify their arrest. Because even if we didn't go that far, I still was going to sue because I knew my rights had been violated. So in any event, the defendants have admitted to destroying the evidence that was used to arrest me. As far as Judge Taleem's ruling, I believe
they have admitted to destroying it.
Yes.
It is their evidence, as I understand it, that that was in accordance with their standard destruction policy. Do you dispute that?
I dispute that. I've never seen a case where you get evidence and then destroy it. And I mean, I wanted a trial on it. And when you have a trial on things, I mean, that's part of due process, isn't it? I mean, where's the evidence at? And it was already tested once. Why is there a need to test it the second time?
It was tested positive for marijuana once. It was tested positive in a lab that it was, in fact, marijuana.
Especially this person is experienced in this. If it's that small and that minute, there's no need to test it a second time. It was already admitted that it was tested. It was already admitted that it was tested positive. And I believe they destroyed it because it was a fabrication. It was a fabrication. And the fact that you have Officer Miller and my vehicle was the only vehicle. I mean, all these things speak to a conspiracy because my vehicle was the only vehicle towed. And this vehicle that had grams and grams of crack is not towed, but my vehicle is towed. I mean, it just, where's the fairness in that?
To prove a conspiracy under civil rights law, it is required that the person making the claim identify very specifically who were the persons that were engaged in an agreement to violate someone's rights. Now, who are the individuals you contend were in an agreement to violate your rights? Does that mean all of the defendants?
Enough. I don't know exactly.
Doesn't tell me a thing.
Now I'm going to quote what Officer Jensen said in his statement.
First, I want to hear what you have to say.
I believe all of them were.
Can I finish?
Yes.
Assume that we have a jury of 8 people here. Usually our civil cases involve 8 jurors. Assume those 8 persons are listening to you make your presentation. What do you tell them about who are the individuals who were involved in this agreement to violate your rights? Who are the conspirators?
Yes. Jensen.
Pardon?
Officer Jensen, the canine officer.
All right.
Detective Canis, Officer Miller. Do you want me to explain why as I name these people? I mean, I thought
I want to know the names, or is it all defendants?
You have, I'm stating all defendants, but there are defendants that I believe I don't have the written proof that the agreement was made, but I do have Officer Jensen's statement where he said it was agreed in his own statement we would just charge all 3. Now, without evidence, it doesn't say who the officers were. He said after, this is his statement, it was decided we would charge Michael Collier, Earl Nimmons, and Calvin Hammock, all with drug possession, delivery, drug tax stamp. Now, the we, I had no...
Oh, Victoria. Victoria, I thought you were Fozzie the whole time, and you are Victoria.
Way of knowing other than the people that have written reports regarding this case. So whoever's name is within the case, that is the only way I was able to even determine. I knew something was wrong, but I didn't know the extent of what was wrong until I actually got the documents, and I haven't received all the documents. Evidence has been withheld. So who knows who else? I don't know the person who was operating the video camera. I don't know his name. But whoever it was, and this is one of my things I'm bringing to the court, is that I don't know the extent of it, because defendants have not been forthcoming with information that is exculpatory. Whether it's exculpatory or finding guilt, they haven't been forthcoming with it.
Well, what I've heard you say is that the agreement was among those three who said, let's charge all three.
I don't know. It could be I don't know. All of them. It was all of them to me. I'm saying the agreement was with all of them. All of them were engaged in a conspiracy to deny my right.
Even you, Eileen. He's getting you too.
Was ongoing. And let me fast forward, Your Honor, to
Let me fast back.
Okay.
You've sued Bill Gluba, mayor, and Frank Donchez, police chief.
Yes.
They had nothing to do with the events of that day, so far as I know from the documents.
Exactly.
How did they conspire?
I'm saying the mayor, being that the police chief is part of the mayor's cabinet, that he is responsible as far as municipal liability and failing to train. And the way I'm able to...
So that's different than conspiracy.
No, the conspiracy was these people were engaged. These people were engaged in a conscious effort to deny my rights. Brad Jensen, Detective Canis, Officer Miller, James Quick. I mean, it goes on and on. I listed it in the complaint.
How would, for instance, Bill Gluba, the mayor, know about what was happening on the day that you were arrested?
How would he know? How it is the same way he wouldn't probably know consciously, but his administration was the one responsible for it because of the pattern. I believe I'm able to show in the evidence from the defendants with their own statements that it's a pattern of behavior. And I believe it's a question for the jury when certain questions are asked of them. The mayor, certain questions are asked of the mayor, the police, the failure to train, the willingness to withhold exculpatory material. Where does this come from? I mean, if you have a job to do and you're told to do the job this way, or even if you're not told, where does it come from? I mean,
okay, without referring to the events of the day that you were arrested.
Yes.
You are going back and saying what happened on that day resulted from an earlier pattern and practice and failure to train.
I am asserting that.
Describe the pattern.
The pattern is in the way it was done to me. The pattern of conspiracy, the conspiracy to deny my constitutional rights was done in my case. I believe I can assert that for the jury, and the jury can find that. And the question is, I believe, can be asked, well, why do you do this? Why, if they think this is the way that it's done, well, who taught you to do it this way? That's my answer to that.
You may now complete your argument. You still have 10 minutes.
Okay, Your Honor. In regards to the marijuana, the officer, the testing officer admittedly destroyed the evidence, which is also a denial of my due process rights. Me being thrown down in the police station, the failure to provide the video, the document that I submitted, Exhibit 4, that shows that the Davenport police have a policy of holding video for 120 days. And you would think, I'm sure there's a policy, which I don't have, but I'm assuming that there's a policy in regards to blood-borne pathogens and bodily fluids and critical incidents. And that would be considered me being thrown on the ground, having to go to a hospital, bodily fluids, being on the floor. That I believe is the definition of a critical incident. There is no video of it. It should have been a video of it. I don't know the person who was operating the video. There's no video because I believe it was done. It was not in the interest of the officers to have the video because it shows the magnitude of how my rights was being violated. The statement was made by one of the officers that I urinated on the floor, but it was made in a dismissive way, like it was minute. Like, I don't know if this is something that happens all the time, and if it is, I believe that should be a matter for and a question for the jury to show municipal liability and the mayor and the chief how they're also responsible. In relation to the numerous pat downs that I received, the defendant's attorney have stated that they have a policy on strip searches. Officer Quick shook me down multiple times, then called over Officer Sievert to continue to shake me down each time, and they admitted this each time. They fondled my genitals. They don't say they fondled my genitals, but they stated that I had crack between my butt. Now, Officer Sievert admitted in his statement that he manipulated his finger trying to get the object out from between my butt. That, to me, is the way it felt, was a body cavity search without getting a search warrant. Ultimately, the search warrant was requested, but if officer, my contention is that if you felt I had something and you were following procedures, then after the first time you shook me down, you should have requested this for the strip search, not continue to fondle me and try to manipulate between my buttocks. And this officer didn't just do it himself, he called over another officer to do it. Officer Quick also in his affidavit, which he just submitted part of this complaint, he stated in the record something that has never been done, and it is indicative. My assertion is that it's an indicative attitude of trying to mislead the court, where Officer Quick, which the defendants, this is in the defendant's motion, is Officer Quick's affidavit. He states that, excuse me, Your Honor. He states on page 2, we also had just taken into custody 2 of his associates, referencing me, who had possession of drugs and had implicated this suspect. That has never been entered into the record, and it's indicative of an attitude to mislead the court. This officer has, he never said that before. That was never in it. Only one person, only one of my co-defendants was caught with drugs, and only one of my co-defendants said that I had gave him the drugs. Mind you, I did not know this person. No contact. Officers viewed from different vantage points. I never had contact with this person, physical or otherwise. My cell phone never had contact with this person. The person that was in my passenger seat of my car that took off running, I'm still perplexed as to why he was running. First thing I'm thinking, he got a warrant, but that has nothing to do with me. It is what it is. He took off running. The officers tackled me. He never left the line of sight of these officers. He never said, he was never found in possession of drugs, and he never said that I gave him drugs. So Officer Quick's statement entering this affidavit into record is shown to be not true. At best, it shows an attitude of not caring. At worst, it shows that he's willing to lie and mislead the court. In relation to, excuse me, in relation to the strip search authorization form that my attorney signed the affidavit to, I just now received that in this case. We didn't receive it before, even after the judge ruled in favor of our
sue him. Sue the judge. Sue the attorney.
I'm basically, these things, I mean, the list goes on and on. There's many unresolved issues of material fact that need to be presented for the jury. As far as qualified immunity, I don't think qualified immunity applies when people consciously, and this is where the conspiracy comes in, it was a conscious decision. These were conscious decisions, not because I say them, but it's even in their own writings and their own statements. They contradict, mislead. I mean, even just the report looking at the vehicle tow and the willingness to put that the 1.8 grams and the 21.6 grams of crack, it misleads the court to think, since my vehicle was towed, this is where the stuff come from. but it doesn't mention the fleck of marijuana that they say came out of my vehicle, which was really fabricated anyway. So when an officer lied and it was done later, and we could say, well, maybe it did happen. But if it happened, why didn't the officer put it on the original affidavit? Because they wanted to find me and charge me for the crack. Didn't even matter to them. But the fact that they had no evidence and I didn't do it, the fact that they seen that, and I don't know if they assumed I was going to sue them, they had to figure out a way, hey, we're going to just say it's marijuana. And I believe a jury will find in my favor because these are issues of fact.
Does this record, the papers that have been filed here in this court, does it show that any of the defendants, one or more, had personal previous contact with you?
I've never had any contact with the Davenport police other than a ticket prior to this incident.
Other than a
traffic ticket.
So you are not contending that any of the defendants had any motivation toward you personally?
Maybe after the arrest, because my attorney, Mr. Geese, told me mind you, when I was arrested, I kept saying, you're violating my rights. You're violating my rights. I kept saying that.
I'm talking about before the day of your arrest.
Not that I'm aware of. Not that I am.
I'm giving him your real name if he asks. I'm telling him who you are.
Consciously aware of. Now, they could have been an attitude against me unknowingly. As far as me being aware of it, no. But when that happened, it showed me that something was going on because I just knew it was such a wrong situation. And my contention is that if they did it like this, I've read many law books, and my contentions were I've never seen a case like that. If they did it like this, they've been doing it. So I was the #1 state incarceration of Black people. I happen to be African American. And when I found that out, this made me understand maybe this is the reason why. So that's my contention.
But so far as you know, none of the defendants had any previous personal contact with you, except I guess you said one traffic ticket.
And I don't even know if that was one of the defendants, the traffic ticket. But as far as personal contact, I don't ever recall, unless I walk by somebody in the mall not knowing they know me, but I don't see why they would know me anyway.
Thank you. That is consistent with what I see in this record now. Final argument on behalf of the defendants, Mr. Jackson.
Your Honor, I'm going to have to be kind of helter-skelter here, and I apologize for it in answering some of the issues that the plaintiff has brought up.
Yes, you are. Yes, you are, Michael.
In the first place, the probable cause for the arrest, and again, has already been ruled upon, and it was actually cocaine. And I'll draw the court's attention to page 7 of the appendix, which is Officer Smith's affidavit. And I'll just quote a sentence from it. Further consideration was given to the fact that his 2 companions had been taken with the indicia of drug sales. I'm sorry.
Once you start reading from something, it goes faster than your voice expected. So keep the court reporter alive here.
I'm sorry.
Be almost as deliberate as I am. Okay. Continue.
Thank you. Further consideration was given to the fact that his 2 companions had been taken with indicia of drug sales, either on their person or had made an attempt to get rid of the drug indicia. And one had made a statement implicating Hammock in the purchase of the drugs. That was the basis for the charge, Your Honor. A statement from an individual who was not able to testify at trial because he turned up dead. Probable cause, again, is abundant for the arrest. The decision to charge or not to charge is the state's attorney and not the Davenport police officers. Another problem that I see here is that the plaintiff quotes from police officers' reports as though they were sworn statements. And indeed, he's attached several of them to his petition. And I'm sure the court's aware of this, but I'd just like to point out that those are officers' narrative reports that are basically designed to serve their own memory for further testimony in court and to, as an aid to the prosecuting attorney. They're not testimony. They're not made under oath. They're not sworn statements. The affidavit is. He makes mention of the fact that his car was the only one towed. That's because both occupants were arrested. The driver of the other car was not arrested and was able to drive the car away. That much, to the extent that it's relevant, is in the police reports that the plaintiff is attached to his petition. He makes mention of collection of bodily fluids. But I think he mistakes urinating on the floor for collection of a bodily fluid. No one at the police department collected any urine from him in any kind of a vial for sampling purposes, nor is he alleged. It's just urinating on the floor. And I'd just like to point out for the court and for the plaintiff that the manipulation that Officer Sievert admits to doing when he was doing the strip search of the plaintiff's crotch area was done to avoid a strip search. When he couldn't get the foreign object to come out, then they had to go to that next more invasive step. And there was no body cavity search, nor was there none alleged. All the plaintiff had to do was cooperate. Furthermore, the failure to train is not alleged in the petition, and it needs to be alleged in the petition for it to be considered by the court. It's too late to change allegations at this point in time. And I think that's all I have to answer for, Your Honor.
I'll give you another minute to reply to what Mr. Jackson has just said, Mr. Hammock.
Yes, Your Honor. I was arrested too. In relation to the vehicle, the defense talking about the reason why my vehicle was the only one seized. I was arrested too.
Judge Fleischer did in fact stop by during the marathon that I did. It was around the 3.5 hour mark ish. I don't know exactly when, but it was in there. And he was amazing. And he was awesome. And I asked him to give Victoria a raise. And Fozzie shouted out to Mary Beth in payroll. And the judge said he was going to tell her that. Yes, he did. And Mary Beth is going to say, who the heck is Fozzie and Kathy? He was great. He really was. He talked a little bit about his challenges with streaming. Just a little bit. And why, why. 333. We did see his fish and we saw his doggy and we saw his beard. Yes, we did. And we heard his voice again. And that was amazing just to hear his voice again.
In relation to the search itself, the Officer Sievert, he admits manipulating his fingers between my buttocks. And it was a gruesome experience, but it just speaks to, if you thought I had something, why not just, you got the strip search authorization form, why not just get it without subjecting me to all that? And even that itself, I have questions about why it was even done. They knew I didn't have anything, but they did it anyway to show, I believe they was trying to just, force their presence on my person. In relation to the, I believe I submitted part of my complaint where the officers, even Detective Canis, during that motion to suppress hearing, all of them say I was arrested for marijuana. All of them say I was arrested for marijuana. After, first I said I was arrested for crack, then it was said I was arrested for marijuana. So, I believe that is a matter for the jury to.
That's because after they tested the things that he had hidden, it was found to be marijuana.
To decide. Yeah.
Thank you. That completes this hearing. It has been videotaped, as you may be aware. You can get it after today, not usually the same day. It is a video streaming situation. It's not as though there were a TV camera, but that is preserved in our files for some time. I will probably take at least 30 days to be able to decide many issues that are raised here in this motion and the response to the motion. I've already got under advisement earlier motions. So I would say don't expect a decision until sometime in March. And if the case does need to have a jury trial, that will be scheduled at a later time. I think the earliest it could be would be June, and more likely it would be November. Mr. Hammock, do you have and it's apparent to me you've done a lot of studying and reading of the law, and perhaps you've also attended jury trials, have you?
I have not attended.
If there is a jury trial, I strongly recommend that before that trial, you go into a courtroom, either here in the U.S. courthouse or in one of the state courthouses, and observe, because you'll be without a lawyer and you need to operate as though you are a lawyer. Do you have a sense right now of how many days it would take you to present your case?
I don't have a sense of that right now.
No one cares.
And that completes the hearing. Thank you. We'll get out a ruling just as soon as I can. Have a nice day.
Thank you, Your Honor.
Okay, so this hearing that we just sat through was a summary judgment. He wanted a summary judgment with all of his claims, and then the lawyer for the police department and the mayor and the state and all those other people, they had their own motions during this hearing of immunity. So this lawyer was saying that the police department has immunity, the mayor has immunity. All these people have immunity, and also that the defendant failed to state a claim in his suit. Well, it went to the appeals. It went in front of the Eighth Circuit Appeals, and then the state won, the police won. So he sued the prosecutors. He sued every person in the hospital that touched him. He sued the individual police officers, the chief of police, the mayor, the state of Iowa. He sued everybody, and they won. He did well. I think he did well for pro se. I think he didn't go off the rails. I think he didn't go into conspiracy theories. A little bit he did, a little bit, but he's pro se. I think he did great. And I think in today's world, now this was a couple years ago, I think in today's world, he probably maybe might have went further. Because there is a pattern. There's documented patterns of police, but we need them. We need the police. They all do a great job and they try their hardest. Okay. This next one is for Charlotte. Bonjour. I know you're not here, but hopefully you see this, because you said nobody ever speaks French. I got French, yo. I got French. Here we go.
Good afternoon, Your Honor. Pierre from the appointed French interpreter, registration 34059.
Thank you. And we have Ms. Anna Kativa here for the people.
Anna Kativa for the people, Judge.
Yeah,
Bonjour,
Mr. Congolo.
Mr. Congo, bon après-midi.
Merci.
Thank you. Good afternoon.
Mr. Congolo, you were going to hire new counsel. We
Vous
have a
devez
file
avoir
date
un autre
of August
avocat
26th.
aujourd'hui. Qu'est-ce qu'il en est? Où est-ce qu'il en est?
J'ai dû parler avec l'avocat et je suis en train d'ajouter l'argent qu'il m'a demandé.
I have found an attorney with whom I'm in a discussion right now. I start to pay but I have not finished to pay because he want me to pay the returner, the entire returner before he shows up.
Well, that might be, and I'm glad you got somebody.
C'est peut-être, je suis heureux que vous avez trouvé quelqu'un.
But we do have that trial date of August 26th.
No, he can't.
Nous avons
He
un
can't.
procès qui est planifié pour le 26 août.
And we have a trial call date of August 15th at 8:30.
Et nous avons les préparations du procès qui est planifié pour le 15 août.
So we're going to keep those dates.
Nous allons garder ces jours-là.
And I would encourage you to get your attorney on board as soon as possible.
Et je vous encourage à finir avec votre avocat aussitôt que possible.
And if you do so,
Et si vous le faites,
and if you want to come in and get on the docket before the August 15th trial call date,
si vous avez terminé avec lui avant le 15 août et que vous voulez venir avec lui rapidement pour voir comment on peut faire pour changer les dates,
have your attorney contact division staff to set it on the docket.
vous pouvez dire aussi à votre avocat, dès que vous l'avez, de contacter mon personnel de sa salle d'audience pour qu'on trouve une date pour que vous veniez avec lui.
Or have your attorney file a motion to get on the docket earlier.
Et donc, nous allons attendre que votre avocat puisse avoir une requête à la cour pour qu'on puisse vous recevoir.
Any questions?
Vous avez une question?
Non.
Non.
Ms. Activa?
Est-ce que vous avez une question au procureur?
And Judge, I am wondering if I'm understanding the court correctly, we do not want to set another appearance of counsel before August?
Pour la cour, est-ce que nous
I can do that.
allons avoir une autre date pour qu'il arrive avec son avocat? Le juge a dit, on peut le faire.
We can set it
Is
the
everybody in
July
chat
meeting.
on drugs right now? Are you all doing like? Did you get some stuff out of that last defendant's butt? Is that why are you trolling me? Is that why you're saying all this stuff? Are you trolling me? I need to know.
Of August, that would be my preference.
Votre honneur, si on peut renvoyer toutes ces dates-là vers la fin d'août, ce serait une très bonne chose.
That's probably a good idea.
Ce serait une bonne chose.
The speedy on this is coming up quickly. We've got a trial date.
Parce que le jugement rapide arrive très rapidement.
All right, I am going to set this for appearance of counsel.
Donc, je vais, en fonction de sa suggestion, je vais vous donner une autre date.
Mr. Congo, how close are you to hiring your attorney?
Monsieur Congolo, la question que vous avez, quelle est la proximité d'avoir votre avocat prêt?
Si je peux avoir encore un mois,
I just need 1 more month to make a payment.
July 28th at 1:30.
Et donc, on vous revoit ici le 28 juillet à 1h30 de l'après-midi.
We'll see you then, okay? For
All
appearance of counsel. Hopefully you'll have your attorney with you.
J'espère que vous aurez votre avocat avec vous.
merci, votre honneur.
Thank you, Your Honor.
You're quite welcome, sir, and thank you, Mr. Interpreter.
You're welcome.
All right. We're adjourned. Thank you.
Okay, your choice. That's all I have. Okay, I have another clip. I do have another clip. Same courtroom, completely different language with an interpreter. And there's a little bit of footage that we get to watch on this TV right here. Okay? It is not the best clip I've ever played. It's just not. Should I play it or should we end the stream now? Like, it's either quality or quantity. That's what we're looking for right now. Do you want me to play this next clip, even though it's not the most exciting? Or do you just want me to start OJ? Chinny says play it. I do everything Chinny says twice.
I brought the parties up because I wanted to have a better understanding of the circumstances surrounding this plea. That's why I had them come up to explain that to me. I'm going to take the plea right now. I'm going to go over the plea agreement with you, okay? I need you to speak in that microphone.
Yes, sir.
All right, and I'm going to ask you to speak in your native tongue. and the interpreter will interpret for you, okay?
कहने की जो भी पूछेगा किसी पंजाबी से जवाब दोगे तो फिर वो समझ जाता है जब से समझाऊंगी
ठीक है जी
that's okay
All right. My understanding is you intend to plead guilty to an added count 16,
इन्होंने 15 लगाए
illegal discharge of a firearm.
इसके बीच कह रहे कि थोड़े हाथ
That's a class 5 felony.
से इस करके वो बता जो नहीं आ गया
In exchange for your guilty plea,
जब मैं अपना कसूर
the people are going to ask the court to dismiss counts 1 through 15.
एक तो लगे 15 सारे
The sentence agreement, as I understand it,
हूं यदि सजा है
it's a probationary sentence, the terms of which are open to the court,
कि वो सारे में
which means the length of time is open to the court, as well as other conditions that the court might impose.
और अदालत भी कोई पाबंदियां ला सकती है थोड़े होते वो भी
Your sentence would be supervised by probation. You'd be required to comply with all standard terms and conditions.
जो भी कानून और रान के
No access to firearms by state or federal law. I would not impose a jail sentence today at the initial sentencing. No restitution required in your case. Pay all fees, costs, and surcharges ordered by the court, and you must surrender any possessory interest you have in the firearm that was the subject matter of this case. Is that your understanding of the plea agreement, sir?
Yes.
Has anyone promised you anything that's not written on this document?
नहीं
No.
I'm going to go over some other documents that were tendered to the court. One is an advisement of the elements of the crime.
ये सारे हैं बड़े हक
This document explains the charge in some legal terms.
कहते हैं ਉਹਦੇ ਵਿੱਚ कुछ कानूनी लफ्ज़
Did you read that document carefully?
वो ਤੁਸੀਂ ਹੁਣ एक ठीक तरह पढ़ना पड़ेगा ਤੁਹਾਨੂੰ ਇਹ ਕਾਗਜ਼
Did you read that document
ਤੁਸੀਂ
carefully?
ਪੜ੍ਹਿਆ ਠੀਕ ਤਰ੍ਹਾਂ ਜੋ ਵੀ ਇਹਦੇ ਵਿੱਚ ਕਾਨੂੰਨੀ ਪਾਬੰਦੀਆਂ ਹਨ ਤੁਹਾਡੀ
ਹਾਂਜੀ।
Yes
And do you understand everything explained in it?
ਸਾਰੇ ਉਹਦੇ ਵਿੱਚ ਜੋ ਵੀ ਲਿਖਿਆ ਹਰ ਇੱਕ ਚੀਜ਼ ਤੁਹਾਨੂੰ ਸਮਝ ਆ ਗਈ
हाँ जी
Yes
Another document they have is a request to plead guilty. It's called Rule 11.
दूसरा है कि 11 नंबर कानून ਦਾ ਹੈ ਕਿ ਕਾਗਜ਼
And this document explains the rights you have
ਇਹਦੇ ਉਹਦੇ ਵਿੱਚ ਇਹ ਹੈ ਕਿ ਤੁਹਾਡੇ ਕੀ ਹੱਕ ਹੈਗੇ
and the rights you give up
ਇਹ ਹੱਕ ਤੁਸੀਂ ਸਾਰੇ ਛੱਡ ਰਹੇ ਹੋ
when you plead guilty
ਜਦ ਤੁਸੀਂ ਆਪਣੇ ਆਪ ਨੂੰ
and the possible penalties you face.
ਹੱਕ ਛੱਡ ਰਹੇ ਹੋ ਜੋ ਤੁਹਾਨੂੰ ਉਹਨਾਂ ਨੇ ਸਜ਼ਾ ਦੇਣਗੇ ਉਹ ਤੁਹਾਨੂੰ ਕਬੂਲ ਹੈਗਾ
Did you read that document carefully?
ਪੜ੍ਹ ਲਿਆ ਤੁਸੀਂ
हाँ जी
Yes
And did you go over it very carefully with Mr. Chrisman?
ਮਿਸਟਰ ਇਹਨਾਂ ਨਾਲ ਆਪਣੇ ਵਕੀਲ ਨਾਲ ਮਿਸਟਰ ਕ੍ਰਿਸ਼ਨ ਨਾਲ ਸਾਰਾ ਕੁਝ ਸਮਝ ਆ ਗਈ ਹੈ ਤੁਹਾਨੂੰ ਠੀਕ
हाँ जी
Yes
And do you understand everything explained in that document?
ਉਹਦੇ ਵਿੱਚ ਇੱਕ ਚੀਜ਼ ਤੁਹਾਨੂੰ ਸਾਰੀ ਸਮਝ ਆ ਗਈ ਉਹਦੇ ਵਿੱਚ ਜੋ ਲਿਖੀ
हाँ जी
Yes
Is there anything interfering with your ability to think clearly here today?
ਕਹਿੰਦੇ ਕਿ ਕੋਈ ਵਜ੍ਹਾ ਹੈ ਜਿਹਦੇ ਕਰਕੇ ਤੁਸੀਂ ਹੋਸ਼ ਆਵਾਜ਼ ਨਹੀਂ ਹੋਈ ਠੀਕ ਤਰ੍ਹਾਂ ਸੋਚ ਸੇ ਸੋਚ ਨਹੀਂ ਸਕਦੇ ਹੋ ਹਮੇ
नहीं
No
Are you thinking clearly today?
ठीक तरह समझ आ रही है
हाँ जी
समझ रहे हो सब कुछ Yes
Has anyone forced you or coerced you in any way to get you to plead guilty?
किसी ने ਤੁਹਾਨੂੰ ਜ਼ਬਰਦਸਤੀ ਕੀਤੀ ਹੈ ਜਾਂ ਵਾਅਦੇ ਦਿੱਤੇ ਨੇ ਕਿ ਤੁਸੀਂ ਇਹ ਆਪਣੇ ਆਪ ਨੂੰ ਕਸੂਰਵਾਰ ਮੰਨੋ
नहीं जी
No
Have you had enough time to talk to Mr. Chrisman about your case?
Sorry
Have you had enough time to talk to Mr. Chrisman about your case?
ਕਾਫੀ ਵਕਤ ਮਿਲ ਗਿਆ ਸੀ ਮਿਸਟਰ ਕ੍ਰਿਸ਼ਨ ਨਾਲ ਸਾਰੀ ਗੱਲਾਂ ਕਰਨ ਲਈ ਸਾਰਾ
हाँ जी
ਸੁਣਨ ਲਈ Yes
Are you satisfied with the services?
ਉਹਨਾਂ ਨੇ ਜੋ ਵੀ ਕਦੀ ਕੰਮ ਕੀਤਾ ਤੁਹਾਡੇ ਲਈ ਤੁਸੀਂ ਉਹਦੇ ਨਾਲ ਸਹਿਮਤ ਹੋ ਖੁਸ਼ ਹੋ
हाँ जी
Yes
And do you want me to accept this agreement?
ਇਹ ਚਾਹੁੰਦੇ ਹੋ ਕਿ ਮੈਂ ਇਹ ਤੁਹਾਡਾ ਜਿਹੜਾ ਸਮਝੌਤਾ ਤੁਸੀਂ ਕੀਤਾ ਹੈ ਉਹ ਮੈਂ ਕਬੂਲ ਕਰਾਂ ਜੱਜ ਪੁੱਛ
हाँ जी
ਰਿਹਾ Yes
Factual basis, Mr. Calvin.
ਮੈਂ ਅਸਲੀ ਗੱਲ ਚ ਕੀ ਹੋਈ ਸੀ ਉਹਦਾ ਪੁੱਛ ਰਿਹਾ
Your Honor, about the date and place charged, Mr. Gill was armed with a firearm near a group of other men, and he discharged that firearm illegally in the direction and vicinity of those other men.
Is that what happened, sir?
ਪੁੱਛ ਰਿਹਾ ਕਿ ਇਹ ਹੋਇਆ ਸੀ ਉਸ ਦਿਨ
हाँ जी
Yes
Do you have any questions for me before we proceed?
ਉਹਨੇ ਕੋਈ ਤੁਹਾਨੂੰ ਸਵਾਲ ਪੁੱਛਣਾ ਹੈ ਜੱਜ ਨੂੰ ਅੱਗੇ ਵਧਣ ਤੋਂ ਪਹਿਲਾਂ
नहीं जी
No Your Honor
How do you plead to added count 16, illegal discharge of a firearm, a class 5 felony?
ਕਹਿੰਦੇ ਕਿ ਨੰਬਰ ਜੋ 16 ਇਹਨਾਂ ਨੇ ਤੁਹਾਡੇ ਤੇ ਇਲਜ਼ਾਮ ਲਗਾਇਆ ਹੈ ਉਹ ਕਿ ਤੁਹਾਡੇ ਕੋਲ ਬੰਦੂਕ ਸੀਗੀ ਤੇ ਉਹ ਤੁਸੀਂ ਆਪਣੇ ਆਪ ਨੂੰ ਕਸੂਰਵਾਰ ਕਹਿ ਰਹੇ ਹੋ
हाँ जी
Yes
Guilty or not guilty?
ਤੁਸੀਂ ਕਸੂਰਵਾਰ ਹੋ ਜਾਂ ਨਹੀਂ
हाँ जी कसूर
I am guilty
I accept your plea. findings made freely, voluntarily, and knowingly. And you expressed a desire to go to immediate sentencing.
The people are ready to proceed, Judge. Mr. Gurdas Singh is available on the WebEx, and I believe intends to make a brief statement to the court, and people are ready to go.
All right, Mr. Crispin, you intend to go to immediate sentencing today?
Yes, thank you, Your Honor.
Is there anyone speaking on behalf of Mr. Gill other than counsel today?
Not today.
All right. Let me hear from Mr. Singh. I had him here a second ago. Mr. Singh, can you hear me?
Yes, I can hear you.
All right. Have you been able to listen to these proceedings so far?
Yes, I listened, but I did not understand the last part. Pretty much I understand.
What part did you understand?
The last part sentencing.
Well, we're at sentencing now. Mr. Gill has pled guilty to illegal discharge of a firearm. It's a Class 5 felony. I've accepted his plea. And now we're at the sentencing phase. And Mr. Kellen has indicated to me that you would like to address the court.
Yes, I understand now.
What would you like me to know, sir?
I don't know.
You can take your time.
Is there any way I can use interpreter, or should I have to talk to?
Do you need the interpreter? I can understand you perfectly fine.
Pretty much Will, we already discussed about with Will.
I'm not understanding this, Mr. Cypher, Mr.
The microphone may have gone out.
No, he's here.
Hello, can you hear me?
There.
Oh, he's already discussed it with you.
I believe he was referring to me, yes, but
Okay.
I don't know if the microphone went out there. Are you? Gurdas, can you hear us?
Yes, Will, I can hear you.
Okay. If this is your chance, we talked about it. You don't have to make a statement, but if there's anything you would like Judge Carpel to hear, now's the time.
Yes, but I don't want Judge, I want to request that mandatory orders. I don't want this guy near to us anytime. I want these orders means for a long time. I don't want these guys to be close to us and with our family.
All right. Anything else you'd like me to know, sir?
No.
All right. I appreciate your comments today. Thank you very much, Mr. Kellen.
Thank you, Judge. And as the court can already kind of see, this case has involved a lot of work, I think, on both sides. I've been working very closely with Mr. Krisman since he was retained on this, and we have met for follow-up interviews with witnesses as well as.
Careful, we're interpreting here, so slow down a little bit.
That's okay.
And frankly, the best evidence of some portions of this incident is the video camera footage, which is then unfortunately nighttime footage where the action is only over in a corner of the screen. So we've spent a lot of time going.
Want to make.
No, I'm okay.
Okay, if you're not, Madam Interpreter, if you're not okay, just let me know and I'll slow down,
I
Mr.
will.
Kellen.
I'll
Okay.
put my hand up. Yeah.
All right, go ahead, Mr. Kellen.
I'm sorry, Judge, I've put a lot of thought into it and there's a lot trying to come out.
Well, I plan to live forever, so take your time.
Judge, this has been a very tough case because it was charged very strongly, and yet immediately it became clear that there was background on why these individuals were in this location that was important and relevant, and that there was also some really, I would say, nitty-gritty analysis needed of the sequence of actions by the men in the parking lot that night. There were two groups of men that met up in the parking lot there, and I think that the evidence would show that there was kind of an expectation that there could be a physical altercation. What ended up happening was some shoving that we can see on some video footage I'm going to play here. Mr. Gill was the only person in the initial set of individuals who had a weapon on his person, and after some shoving, he pulls that weapon out and fires it. And that's the shot that is the focus of my prosecution here today, Judge. I believe that If we had proceeded to trial, I would have proceeded under the theory of attempted second-degree assault, extreme indifference for that shot. Then after that, it then becomes kind of messy as well. And Judge, I'm going to switch over and try to play a portion of that video so the court can see what I'm referring to. And Judge, I'll play it through once and then I'll try to slow it down and play it slower, but everything we're looking at is in the upper right corner of the individuals next to the I'll try to slow it down and play it slower, but everything we're looking at is in the upper right corner of the individuals next to the
I heard you twice there, Mr. Calvin.
We're looking at is in the upper right corner of the individuals next to the
I heard you twice there, Mr. Calvin. I'm just gonna mute it.
Sorry about that. And the judge, the video stuttered there towards the end. I'm going to back it up and just play the first part, which I believe is the most critical one more time. I'm slowing this down to 50% speed now. It doesn't make it very much easier to view. And Judge, unfortunately, the original video then has a little bit of a hitch at that point in there. So
I think I get the point.
there's a separate angle that I'm not going to show today, but it essentially shows the gentleman in the right side of that frame then retreating one after the other back towards their vehicle, retrieving a weapon, and then there's further shots fired after that point.
All right.
Judge, so this is essentially the evidence that the people had to work with, along with the statements by all of the different participants that were made to the investigating officers regarding the background relationships here. Judge, I think that at trial, this would have, the charge I would have been moving to prove would have been attempted second-degree assault, extreme indifference. Based on that, I think that this is an appropriate plea agreement. Mr. Gill does not have a prior criminal history, and up until this incident, he did have a concealed carry permit for that weapon. So, Judge, I think this is an appropriate resolution to this, given the factual issues here. I ask the court to accept the agreement and place Mr. Gill on probation.
What are you asking for in terms of the length of probation?
Judge, my typical request is 2 years of probation. I'm going to ask for that amount of time. I'm specifically going to ask that the court order that the mandatory protection order remain in effect as currently constituted throughout the duration of probation. That was Mr. Singh's primary request, as well as the primary concern of the other victims when I spoke with them previously.
Sorry.
The mandatory protection order, that was his request, and the request of the other victims as well. Judge, beyond that,
1 sec. Are you caught up now?
Yes.
Okay.
Beyond that, I would just ask for any other terms and conditions that the court deems appropriate, as well as an order that he report to probation within 24 hours.
All right. Mr. Crispin.
Thank you, Your Honor. First of all, I can tell the court that both parties worked together in concert over the course of several months. There was an extensive defense investigation, and Mr. Callan actually touched on it very, very astutely, that this was charged strongly to begin with. And I believe it was largely because the video that Mr. Callan just showed actually glitches after that. And what you didn't see, Your Honor, is actually video footage not released by the alleged victims for some time, because they owned the corner grocery store in that parking lot. So there was another vantage point. that vantage point shows from that point going forward actually more context. And so if you, as the court can see, yes, Mr. Gill fired into the ground, but the court can also see that he was retreating at the moment when he was getting pushed backward. Very granular, there's some discrepancy on who pushed first, but there's no doubt that Mr. Gill is being pushed backward before he shoots toward the ground. What occurs after that is the parties, Mr. Gill and his friend, Mr. Dillon, stop firing altogether. The two individuals who had approached them to begin with go back to their car, retrieve firearms. Two other individuals come out of the car with firearms, and suddenly there are four people shooting at Mr. Gill and Mr. Dillon. At the end of the day, it was Mr. Dillon who was shot 3 times. Mr. Gill drove him to the hospital where law enforcement told him that he did nothing wrong. That law enforcement officer had seen the surveillance footage at that point. So at this, frankly, Mr. Gill came to me almost unable to think clearly because he's suddenly charged with attempted first-degree murder when he was pushed first and his friend was the one with bullet holes in him. And we're talking about victims who put bullet holes in people and the only ones who have bullet holes. So this has been a fraught case for sure. And I think that there's plenty of evidence to suggest that Mr. Gill certainly had no expectation that there was going to be violence that day. Other folks may have known, but Mr. Gill did not. So Your Honor, I'll end with this. Obviously, that's why we're at the point where the charges are so different from the plea agreement. But what I can also tell the court is that Mr. Gill is an incredible man. And it's been a pleasure he's an incredible man. And it's been a pleasure fighting for him. This is a man who has worked hard his whole life. He is an entrepreneur, runs a convenience store in the mountains in Kittredge, and really was put in a bad place by the other individuals that were here and part of this. That's my opinion. What I can tell the court is his family has been supportive and here with him at every court appearance. And this was a very difficult decision for the family. But I am also quite grateful for Mr. Callan that we were able to reach this. I think it's fair given the risks of what would have outed a trial. And so, for the interests of justice and judicial efficiency, I don't think there's any need for a trial because we arrived at the right resolution here after everything would have shaken out. So my hope is that you accept this plea agreement as it is, Your Honor. It's the result of a lot of analysis from folks who are highly invested in this case. Thank you.
All right. Thank you, Mr. Chrisman. Before I hear from Mr. Singh, if he wants to talk to you, this gentleman in the back might want to, you want to talk to him in the green and find out if he wants to talk to the court, address the court. You seem to express some animation here.
Yeah, Your Honor, he's the individual who was shot. So he's not a listed victim. He doesn't have standing right now, but he has been supportive throughout his.
Okay, I just wanted to make it. I wasn't ignoring you, sir. I want you to know that. Okay. All right, Mr. Gill, what would you like me to know, sir?
No, Your Honor, I don't want to say anything at this time.
Well, now'd be the time if you have anything to say.
Your Honor, may we have just a brief moment?
Of course.
Don't worry, it really is brief. They just talk for a second with an interpreter, so that's impressive.
Your Honor, I don't want to say anything at this time, but I just want to apologize and ask for your forgiveness.
Well,
Yes.
I just don't know what you guys just said right there.
No. He said, I don't want to say anything at this time, but I would like to apologize to the court and ask for my forgiveness and please excuse me. And whatever the court decides, it's fine with me.
All right, thank you, Mr. Gill. I appreciate your words. It's the forgiveness of the victims that you should seek, not mine. It's a very convoluted case, complex case. I very much appreciate the work that was put in by Mr. Crispin and also Mr. Kellen. And that gives the court great comfort to have that kind of quality representation and prosecution, that we reached, that a just resolution was reached here. So I will accept, here's what I'm going to do. I accept the plea to add count 16, illegal discharge of a firearm. That's a class 5 felony. Counts 1 through 15 are hereby dismissed. I hereby send you to probation for 3 years. That comes with standard terms and conditions to be supervised probation. You must not have any access to firearms by state or federal law. I'm ordering you to perform 100 hours of useful public service. The mandatory protection order remains in place.
What was that, Your Honor?
The mandatory protection order remains in place. You are to have no contact, directly or indirectly, with the protected parties, Mr. Singh and Mr. Singh. No restitution is being asked for in your case, so none is required. Pay all fees, costs, and surcharges ordered by the court. You must forfeit your possessory interest in the firearm that was the subject matter of this case. I'm going to order you to go to probation now. They're right in the courthouse next door. Let them know that you've pled. Let them know that you want to get started on your probation so you can be successful.
Whoa, wait. Did you hear that? Okay. Oh, gosh. Where are we? We are, oh, sugar. Oh, darn it. It doesn't say. Okay. Tell me if I'm wrong. All right. Does this look like Eric Johnson, the ponderer? Does this look like his type of courtroom? So this judge is in a different spot and the cameras are in a different angle. But if you didn't look at this whole side of the screen and you only looked right here, and there was a golden statue right here, that would look pretty close to Judge Eric Johnson's courtroom, right? I think so. All right, but here I'm going. Here's where I'm going with this. Hold on. So we see that. So we're figuring out where these courtrooms are. All right. So he just said probation is right next door. All right. But Judge Blanco, she says probation is across the street. So now we know that at least there's this courtroom where where Eric and David are together. Blanco is across the street. There's at least 2 courtrooms, courthouses there. And we'll probably get we'll get more. I mean, there's different counties too. So we're just trying to figure out where all these courthouses are in. Like, I know Harris County because I was there and I saw the great big civil building and then the criminal. But all right, so actually he's probably right down the hall from Judge Johnson. And speaking of Colorado, let's talk about Indiana. Today is the 6th. I don't remember what's happening, but in 3 days, you guys were supposed to remind me about a pro se trial with Judge Saber. I remember. It's 3 days away, and I remember, and I'm going to get it, even though I don't really remember what it is. I'm going to get it, in case you all were worried. Don't be worried. Thanks, Clarice.
Other than vacating some dates here for Mr. Gill.
Shut up, JK.
Nothing further from the people.
Mr. Crispin?
I don't believe there are any other housekeeping issues, Your Honor.
All right, the motion's date of July 30th is hereby vacated. The trial call date of September 2nd is hereby vacated. And the trial date of September 9th is hereby vacated. Mr. Gill, I wish you the very best of luck, sir.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Madam Interpreter. I really appreciate it. Thank you.
I meant to unpause it, and instead I started the video all over again because I'm a freaking professional. That's why. Oh, sugar. All right. That's what I have for today. It should automatically direct you to OJ. Gross dog. Yeah, oh well. Which was supposed to start a few minutes ago. Victoria, tell the judge we still miss him. CJ sent me a text, which I will forward to you if that's okay with you, CJ, on some ideas for the judge. That still the same. It's still going to be the same, but maybe it'd be better if he decides, which it doesn't sound like he's close to deciding right now. I know he wants to, but he doesn't want to. And the doesn't want to is winning right now. But that's okay. We do miss your page 13 a lot. Like way more than I thought we would. It's bad. But that's fine. It's fine. Tell him I'm just going to go get Juanita instead. Tell him that. Actually, if you see Juanita at lunch this week, tell her I still get her, but it's still really bad. I could text her, but I feel scared texting her. And tell her I feel scared texting her. I don't know. Victoria's my biatch. Yes, she is. All right. I hope that all of you in Texas survived that the flash floods that just wiped you all out. And I hope that you guys, that my vibers are okay. Good. Feel free to talk in Discord if you're not. Let us know. All right? Thanks for coming out today, guys. I really appreciate it. I shall see you all again really, really soon. Have a great day. Bye. You wish you lived near Bill. You wish you could just walk out of your house and see Bill every day. Now I have to say goodbye again. Damn it. Goodbye, everybody. Have a good day.
Got these lights that goes digital dreams through the screen. Her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Street tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Her eyes near a sky so blue. In her jokes there's a truth so true. With each stream she brings the light, turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle she lights the way. Kathy's laugh